The UNCITRAL Arbitration rules stand as a cornerstone of international dispute resolution. Developed by the United Nations Commission on International Trade Law, or UNCITRAL, these rules offer a comprehensive framework for conducting fair and efficient arbitration proceedings. Born from a need for harmonized global standards, the UNCITRAL arbitration rules have gained widespread acceptance as a reliable and balanced system for resolving cross-border commercial disputes. However, they are not without criticism. Some of the main critiques include concerns about cost, complexity, transparency, and potential bias. Critics argue that the actual cost of arbitration under UNCITRAL rules can be high, with expenses escalating due to multiple arbitrators, lengthy proceedings, and expensive legal representation. Additionally, while the rules provide some guidance on costs, they lack robust mechanisms to control or limit expenses, particularly in complex cases. The comprehensive nature of the rules can lead to complex and lengthy procedures, posing challenges for parties without significant experience in international arbitration. Furthermore, the 2013 amendments introducing transparency in investor-state arbitration have raised concerns about undermining confidentiality. Critics also point out that arbitration under the UNCITRAL rules can sometimes be drawn out, leading to delays in resolving disputes. The process of enforcing awards can be challenging, particularly in jurisdictions with weaker legal systems, and the finality of awards offers limited scope for appeal. Concerns about perceived bias in arbitrator selection and the ad hoc nature of arbitration without institutional support also highlight potential drawbacks. The rules may be too complex and costly for smaller disputes, making them less suitable for parties seeking quick and inexpensive resolutions. While designed to be neutral, the rules may not always account for cultural and legal differences, leading to dissatisfaction in certain contexts. Despite these criticisms, the UNCITRAL arbitration rules remain a testament to international cooperation in facilitating global trade. By providing a neutral and predictable framework for resolving disputes, these rules foster confidence and stability in cross-border transactions. Over the years, several major amendments have been introduced to address these concerns and enhance the effectiveness of the rules. The 2010 revision, for instance, introduced provisions for appointing emergency arbitrators to handle urgent interim measures. The 2013 amendments focused on transparency in investor-state arbitration, aiming to balance public interest with confidentiality. More recently, the 2021 updates have streamlined procedures and introduced new guidelines for virtual hearings, reflecting the evolving landscape of international arbitration. Some of the major rules include the appointment of arbitrators, the conduct of proceedings, and the making of awards. The rules provide detailed procedures for the appointment of arbitrators, ensuring impartiality and independence. They outline the conduct of proceedings, including the submission of statements, hearings, and evidence. The making of awards is also covered, with provisions for the form, effect, and correction of awards. As we explore the intricacies of these rules, we'll gain a deeper appreciation for their role in promoting fairness, efficiency, and the rule of law in the global marketplace. The UNCITRAL arbitration rules are designed to apply to a broad spectrum of international commercial disputes. They are crafted to be versatile and adaptable, accommodating a variety of contractual relationships and subject matters. Whether it's a dispute over intellectual property rights, a breach of a sales contract, or a shareholder disagreement, the UNCITRAL arbitration rules provide a neutral framework for resolving these disputes fairly and effectively. The flexibility of the rules is evident in their ability to be incorporated into various types of arbitration agreements. Parties can choose to apply the UNCITRAL arbitration rules to ad hoc arbitrations, where they establish the procedural framework themselves. Alternatively, they can opt for institutional arbitration, where the rules are administered by an established arbitral institution like the International Chamber of Commerce or the Singapore International Arbitration Center. This adaptability is crucial in today's globalized business environment, where transactions often involve parties from different legal systems and cultures. The UNCITRAL arbitration rules provide a common ground, a set of internationally recognized standards that ensure fairness and due process regardless of the parties' backgrounds or the specific nature of the dispute. By offering a clear and predictable framework, the UNCITRAL arbitration rules promote confidence among parties engaged in cross-border transactions. They provide a sense of security, knowing that any disputes arising from their agreements can be resolved fairly and efficiently under a globally accepted set of rules. This, in turn, facilitates international trade and investment by mitigating the legal risks associated with cross-border commerce. Central to the UNCITRAL arbitration rules is the concept of a neutral and impartial arbitral tribunal responsible for adjudicating the dispute. The rules outline a clear and balanced process for selecting and appointing arbitrators, ensuring fairness and impartiality from the outset. Parties can choose a sole arbitrator or a panel of 3, depending on the complexity and value of the dispute. The rules emphasize party autonomy, allowing the parties to agree on the method for appointing the arbitrators. They can nominate arbitrators directly, utilize a list procedure, or entrust the appointment to a designated appointing authority. This flexibility allows parties to tailor the selection process to their specific needs and preferences. To safeguard impartiality, the UNCITRAL arbitration rules include stringent requirements for arbitrator disclosure. Potential arbitrators must disclose any circumstances that could raise doubts about their independence or impartiality. This ensures transparency and allows parties to make informed decisions about the suitability of the arbitrators. The rules also provide mechanisms for challenging and replacing arbitrators if justifiable concerns arise, further reinforcing the principles of fairness and neutrality in the arbitration process. A cornerstone of the UNCITRAL arbitration rules is the principle of party autonomy. This principle recognizes the right of parties to tailor the arbitral process to their specific needs and circumstances. The rules provide a framework, but within that framework, parties have significant flexibility to shape the proceedings to best suit their dispute. This flexibility manifests in several ways. Parties can determine the language of the arbitration, the seat of the arbitration, which influences the applicable law, and the rules of evidence that will govern the proceedings. They can also agree on expedited procedures for simpler or lower value disputes. This ability to customize the process ensures that the arbitration is efficient and cost-effective, taking into account the specific characteristics of the dispute and the parties involved. The UNCITRAL arbitration rules recognize that one size does not fit all in international arbitration. By empowering parties to shape the process, the rules encourage cooperation and help ensure that the arbitration is conducted in a manner that is fair, efficient, and ultimately leads to a mutually acceptable resolution. This adaptability is particularly valuable in complex international disputes where the needs and expectations of parties from different legal cultures can vary significantly.